Forgive me. One moment. My name is what you asked for?
I did.
No, I'm not Peyton Ansley John Milton. I'm the agent authorized to represent Peyton Ansley John Milton as written in all.
And as to Mr. Milton, is there a competency concern, or is this
I am not represented by anybody besides myself.
Okay, Your Honor, I did have an opportunity to speak to him. I read him the reports. He was
Who is him?
Don't interrupt. I'm letting
I read him.
Langley
I
go.
read
Now,
him.
You just sit quietly.
Thank you.
I read him the report so that he will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented. Thank you.
Right from the start, you can feel the tension. Instead of simply stating his name, Peyton Milton declares he's the agent authorized to represent himself. This is classic sovereign citizen language, an attempt to separate the person from the agent. For viewers, this is a warning sign. When someone walks into court with this mindset, the odds of a smooth hearing drop to zero.
Done.
Okay.
Have a seat.
You got it.
And thank you. Mr. Sheriff, any probable cause application to be the truth, whole truth, and nothing but the truth.
I so swear, Your Honor. Information comes from a report of Officer Evers of the Lacey Police Department. She writes that on March 31st this year at approximately 13:53 hours, she responded to an unwanted person complaint at a 7-Eleven store located at 2425 Marvin Road Northeast in Lacey. Dispatch advised a male was refusing to leave the store and was being disorderly, yelling at staff. Upon arriving, Officer Evers contacted staff, who advised her that it was a white male, approximately 5'5", with a beard, wearing green long-sleeved flannel. Staff advised that he was intoxicated and belligerent. They advised that at one point the male stated he would be waiting outside when they got off work. The staff advised that they asked the male to leave multiple times and he refused. They also advised that once they called the police, the male returned to his Toyota 4Runner, and the license plate is provided here, and then that it was parked outside the gas station. Staff provided a prepaid phone and a charger that the male had left on the floor inside. To feel safe, wanted the male trespassed. Officer made contact with the male and immediately was able to identify him as Peyton Milton. Officer knows Mr. Milton is a local transient that lives out of his car, has had several social contacts with him. Evers asked Mr. Milton if he was just inside the store. He stated that he was. He stated that he was too drunk to be held accountable. Sir advised Mr. Milton that he'd be trespassed from the 7-Eleven, and he stated, "I understand what you have to do." Mr. Milton offered to manually push his car to a gravel lot about 25 yards from the 7-Eleven so that he wasn't on the property, since he was too intoxicated to drive. Officer agreed and gave Mr. Milton until nightfall to push Mr. Milton with his phone. And he replied, "Can I go back in and charge it?" Asked him that he could not charge his phone at this 7-Eleven and that if he entered the store again, he would be arrested. Officer provided Mr. Milton with a copy of the trespass form. Staff called dispatch, advising that Mr. Milton was back inside the store. Staff advised that Mr. Milton said he was too drunk to be held accountable, and that he left again once they called dispatch, and this time he again left his cell phone in the store. Officer then contacted Mr. Milton. He again stated that he was too drunk to be held accountable. Officer noted that Mr. Peyton was intoxicated but functional and able to understand.
Listen carefully to the officer's report. The staff gave him chance after chance. He was literally offered time to push his own car off the property instead of being arrested. Yet he came back, saying he was too drunk to be held accountable. This part humanizes the case. A homeless man, intoxicated, but also a 7-Eleven staff terrified of him returning.
And Mr. Milton is asking not to be represented by counsel. Is that correct?
That is correct, Your Honor.
Choose to represent yourself, which is your right. You can make that choice, but I want to make sure that we make a record that you are doing so knowingly and voluntarily. Ms. Langley is an attorney. I'm going to guess that you have not gone to law school and become a member of the bar. Is that correct?
I can neither confirm nor deny that information, actually.
So not being an attorney, you understand that if you represent yourself in recognition of the fact that you're not an attorney, so you will end up missing things you're supposed to do, you will do things you're not supposed to do, and all of those things will likely work. So it is never a smart thing to represent yourself. And frankly, if an attorney were to say they would represent themselves, I would have the same conversation with them and advise them I think it's a foolish decision to make. You, however, have that right, as I pointed out, but I want to make sure you understand you have the right to have counsel. You have the right to have me appoint counsel, or you can hire counsel. And if you ask me to appoint counsel, I can appoint counsel at no cost. So you understand all of that.
I appreciate that, and I do. Thank you.
And how do you choose to go forward? All right, I won't appoint counsel to represent you. You'll have to represent yourself on both cases, the criminal trespass charge and the city's request to revoke these continuance and get a conviction on the assault.
The judge now gives one of the most blunt explanations of why self-representation is risky. He's practically pleading with Peyton to take a lawyer. This isn't just legal advice, it's a lifeline. Even lawyers don't represent themselves, but Peyton doubles down.
And they needed him to appear in person to deal with that.
I was not read my Miranda rights this most recent time. I believe I'm supposed to request a voyeur of the body cams.
Like I said, I can't represent you. You're going to have to figure all that out yourself for purposes of today.
I'll require 4 to 6 hours of unhindered internet access so that I can properly represent myself. If you would write that into a court order.
Read your form on your constitutional rights.
Did I read my form? I don't believe I was provided anything.
Okay, is there a corrections officer there? Let's present Mr. Milton a copy of the rights form and have him read it. And then he and I can talk about it.
Yes, Your Honor, there's one taped to the desk right in front of it.
Okay, why don't you take a minute and read it? Let me know when.
I haven't been Mirandized, so it's hard for me to even start since I can't technically be charged with anything. And there's no victim in this alleged crime.
Okay, I know. All I'm asking right now is for you to read the rights and tell me that you have done so.
All right. Would you please silence? I have completed the reading, sir.
All right, thank you. I'll talk about that with you in just a moment as soon as I finish this document I'm working on.
Thank you.
Any question about those rights that are on that form?
Here's where the courtroom tilts from sad to surreal. Peyton claims he wasn't Mirandized and demands 4 to 6 hours of unhindered internet access to represent himself. This shows a deep misunderstanding of how rights work and how jails operate. It's also a reminder, the court can't be your Google.
The same day that Officer Tittle refused to search the man who stole my key. Unless you would allow me to fill in some details that they failed to read me my Miranda rights, and I wasn't taken a statement from in both questioned cases in question.
Of Miranda tells us is that if you make any statements while under arrest prior to being read your Miranda rights, the prosecutor is limited in its ability to present those statements to the court. It doesn't have any other purpose other than whether something you say can be used against you. That's the whole purpose of Miranda. Doesn't mean they can't go forward with a criminal charge.
I was never aware of that.
Right, which is one of the reasons you don't want to represent yourself, but you know, I've explained that to you now, but I just want to make sure. So you still wish to represent yourself?
Absolutely.
Notice Peyton's plea for personal recognizance. He tells a story of stolen property, defending an elderly man, and feeling wronged. Whether true or not, this is the emotional core. A man who feels the system has already taken everything and now won't give him his freedom.
Allowed to throw on a bail is $300 and I have to bail out for 2 things, then I'm certain I would need to acquire a phone number that I don't have in order to make that happen. And so I would have to say that it may be closer to impossible.
The bail here is usually 10% of what's ordered. So $50 on each case is what a bonding company would want from you. So just, I don't know whether that
Well, I have
changes anything.
$100. Isn't that
Okay, all right. Thank you. I will set this for 3 weeks from today at 1:30 in the afternoon. So on what we call a pretrial, Mr. Milton. And at the pretrial hearing, you will have received information from the city prior to that as to any offer to settle the case. Just so you know, you don't have to accept it. But they will be contacting you to give you whatever offer they have. And then you'll tell the court at that time whether you wish to accept the offer and enter whatever arrangement is made.
The judge has no choice. With an active warrant and a new trespass charge, Bail is set at $500 on each count. You can hear the disappointment in Peyton's voice. He can't afford it, but the law doesn't bend just because someone refuses legal help.
Speaking
They've
of,
heard
by
you,
the
and
way,
Mr. Sharp has heard you, and we'll go
on
forward that
on a
way.
side note, if I may, Your Honor, during intake, and I might preface this with, I have gone to anti-kidnapping training. I was inhumanely subject to what I would define as torturous actions. It was by C.O. Patero against the man, but he only sought to escalate a situation physically that could have been de-escalated with a verbal warning, a verbal, hey, knock your stuff off, a verbal. And I was completely compliant physically, as you can see on camera if you look in holding C on the night that I was in. I was asked to be picked up and seated. They had refused and told me on their paper that they checked on me every 15 minutes when I was checked on about 3 times the first 2 hours and about twice.
This part is jaw-dropping. Peyton brings up anti-kidnapping training and torture in intake. Whether exaggerated or not, it adds a dark twist. Viewers see not just legal conflict, but human breakdown. A man at war with the entire system.
Kind of one of two routes to take. They can either take it to trial or plead guilty, or the state can, or the prosecuting authority could dismiss. So I was told you want to plead guilty here today, and once you plead guilty, it's true. All the rights contained in paragraph 5 of that plea form go away.
I don't know.
Hang on, let me finish, please.
Yeah, sure.
If
Yes,
you
Your
don't
Honor.
want to do that, then you don't have to, and then we'll just set this for trial, and this case will resume. So that's where we're at here. And if you want to go into a breakout room with Ms. Langley to discuss this further, you can do that if you wish.
Yeah, I just want to clarify, this would be an SOC, not a plea of guilty.
Okay. Well, that's true that if the thank you, Ms. Langley. If the stipulation in order of convenience is true, the guilt or innocence will be determined by a reading of the police report. So what's happening there is you're giving up your right to a trial, the right to present evidence, but what you're getting is the opportunity to have this thing completely dismissed. And so if you don't want, again, if you don't have to do that either if you don't want to, but that's what's happening here today.
Well, Your Honor, what I'd really like is for, first off, my statement to be taken. Second off, for details that are imperative to my defense to be taken. And realistically, I'd hate to be incarcerated for a crime that I didn't commit against an assailant who's known to assault people who are elderly and weaker than him. None of this appears to be making very much sense to me, and I'm sure that you can relate to why I would feel that way.
The judge calmly explains the SOC agreement versus a guilty plea. Peyton still resists. This ending highlights the whole theme. A defendant convinced he's beating the system. But in reality, each refusal may be closing the doors that could actually help him.